Hi, good afternoon. Welcome to the third question and answer session for the Domestic Relations Division. We're so happy you guys are here joining us. My name is Vicki Kelly, and I'm the chair of the Family Law Committee this year. I'm being joined by Rebecca Kozakowski, this year's vice chair, and Wendy Musilek, the DCBA president. I'm sure that you can see we have a full panel today. We have some people logging in right now, so our panel will get bigger and bigger. Today we'll have the following judges: Judge McJoint, Judge Felice, Judge Douglas, Judge Reedy, Judge Sexton, Judge Davenport, Judge Alvarado, and Judge Cerny. So thank you so much for joining us. From the clerk's office, we'll have Jignesh Shah, Suzanne Armstrong, Lisa Goodwin, Kevin Vasky, and Jeff Davies. We also have Sean McCumber joining us from Sullivan, Taylor, Gumina, and Palmer, and he's going to do a presentation on electronic orders. So we have a lot on our plate today. The order of the events for today will be announcements. We will then get an update from Judge McJoint. We will receive a presentation from the clerks with regards to Zoom scheduling. Sean will do his presentation on electronic orders. And finally, everyone's favorite part, the question and answer session. If you haven't yet renewed your DCBA membership, you have until August 31st, at which time your membership will be suspended. We have two upcoming PRMCLE programs. The first one is tomorrow, July 22nd. It's part of the Basic Skills Program. Judge Schwartz and Judge Spearin will show and share how civility and professionalism will best service clients effectively in the long run and how they affect your reputation. On Wednesday, July 29th, Dr. Chris Mazzarella will provide a mastermind class on how to have the hard conversation during COVID-19 and beyond. This will qualify for 1.5 hours of mental health and substance abuse professional responsibility credit. The annual DCBA golf outing is August 26th at the Naperville Country Club. Registration is now open, and I hope that somebody beats my team because we came in last year. The formal DCBA installation and president celebration is currently scheduled for Friday, September 18th at the Doubletree in Lisle. The DuPage Association of Women Lawyers installation is currently scheduled for September 24th at the Arrowhead Golf Club. And the DCBA and DAWL will be hosting a joint judicial reception on October 22nd at the Donata House. Judge McJoint, why don't you take over with your updates?
Thanks, Vicki. First of all, Suzanne Armstrong is now at the clerk's office. She runs the building, but that's okay. Couple things. Probably the most important thing everyone wants to know: when will the domestic relations rooms open for real, in person? And the answer is, I have no idea. I can tell you it's probably not going to be very soon. Which I'm sure everyone's maybe unhappy with. So my advice to all the lawyers: all your in-person dates you have in August, start flipping them right now to Zoom. I can't even suggest anything about September or after that, but at least do that so you stay ahead of the curve here. And as you know, the process for doing that is to contact the schedulers in domestic relations with the remote scheduling form, so that we can send the invites to you to convert an in-person proceeding to a Zoom. And that's the bad news there, but there's a lot of good news coming up too. Couple other things: help desk. We're looking into reopening it. It's going to be probably a different format, probably utilizing Zoom. We're just exploring ways to do that now. So be aware, we might be coming back at you asking for volunteers to man the help desk when we finally get it up and running again. We all feel it should be up and running again. As you all know, Judge Sexton's courtroom is open for in-person right now. It has been for a couple of weeks. And of course, much of her clientele utilizes those services. We have now, I think, finally got the CRIS system to allow you, the lawyers, to see all our court calls on a daily basis, which then allows you to kind of peruse what day you'd like and what day is available, and then call the schedulers and grab your day for a Zoom. And I'm told that's now up and running, which is great. I want to make sure all the lawyers are aware of our latest administrative order, which allows the domestic relations judges to conduct in-person proceedings for exigent matters. And as you may or may not know, exigent matters is determined by the judge. Primarily, these matters are going to be and have been heard in the afternoon. They're in the nature of extended hearings or trials. If the judge determines it's exigent, and it's defined in the administrative order, then you can proceed in person. So we want to make sure everyone is aware of that, because I know in every other county they're doing it different, and I know it's really hard to follow all the rules that vary from county to county. So that's what we're doing now. I call it a soft opening of domestic relations. It's been available now for 2 to 3 weeks. So it's there if you need it, and if you can convince your judge your matter is exigent. The other really interesting thing, and we're going to hear all about it here in a few minutes, is a new way to schedule Zooms. And you'll all be quite happy with it, because it's really going to simplify the process. Because as we all know, and I think we all agree, Zoom is not going away. When we reopen for real, for all in person, Zoom is not going away. Most people are asking me for Zooms into September, and and farther. So it's probably something we probably should have been doing for years, guys, but it took a virus to drag us into this. But in any event, it allows you to be in multiple counties within an hour, and it really is pretty slick how it works. So Zoom is going to be here forever. So you're going to hear about a way to schedule these Zoom meetings with much more ease. We also will hear about the Zoom matters we've set already that are going to occur after the flip into this new system. And there's a date they picked flipping into the new system. You'll hear all about that. I'm not going to steal their thunder. But you need to understand that Zoom is not going to be pulled back or taken away ever. Same with remote prove-ups. It's here to stay. Zoom pretrials, Zoom presentments, it's all here to stay. Court call is here to stay, regardless of when we reopen. So it's a new world for us all. And those are all the comments I have. So I'm going to turn it back to Vicki. Thanks.
Thank you. Okay, so we're going to move on to our presentation from the clerk's office. So everyone a part of that presentation can unmute, and you've got the Zoom.
Thank you. I am going to share my screen. So hopefully that is working for you now. Vicki, can you confirm?
I'm muted. Yes, we can see your screen.
Okay.
Thank you.
So, so what the clerk's office is doing is anytime you have a activity and a continuance for a video call or a video hearing on a date set up on your case, the night before the case is due to be heard in court, the clerk's office is going to run a process and automatically create Zoom meeting links for anything on a specific judge's call in a specific courtroom at a specific time. Now, specifically for the domestic relations, I think you just heard that if you do need something scheduled, something put on the call, you do have to call the domestic relations scheduler and submit the form, to request a video hearing. And once that gets on the court case, then our software will intercept it and create the Zoom meetings automatically. So we have made an enhancement to our website, and this will become live. We're currently scheduled to go live with this on August 10th, which is a Monday. And so right now you're looking at our test website. And if you go to our website called 18thjudicial.org, you'll see a new icon here at the top. It's called Remote Zoom Hearings, or Remote Court Hearings, and it brings you to this website, this webpage. And so you'll enter your courtroom, and we can choose 3009, and the date will default to today. And to prevent, some data harvesting, you click the I am not a robot link and search schedule. Now, what this is doing is for every court case that has a for video hearing scheduled in it for 3009 today, you will see all these search results. So you'll see that now we have this court case here, and this is the case title. The session time is scheduled for 9:30 a.m. and it gives you a meeting and ID and a passcode and also a phone bridge. So if you have problems launching the Zoom app directly from your device, you can always go to zoom.us and you can enter this meeting ID and this passcode manually. But it'll be much easier if you just click the Join Now button and then you choose to run the little Zoom app. And now I am not going to get out of this meeting. So I'll say no here. But this will now bring up your Zoom meeting for your court case at 8:30 in the morning. So you'll see here that these times are not necessarily scheduled in 15 or 20 minute or 30-minute intervals. So you do have to know what time your individual domestic relations court case is being heard at. So you'll see this one is at 8:30, this one's at 8:45, this one's at 9:30, so 45 minutes later. So I think I would like to say on behalf of the judges that if your case is not, if you are not admitted to a waiting room specifically at the start time of your case, then the previous conference call is probably being delayed. So when you join the meeting, you'll be put into a waiting room most likely, and then the judge will admit you from that meeting and start the meeting at the proper time when he or she is ready. If you do have a Zoom meeting that has already been scheduled, there are some of them coming up in the near future for like the middle to the end of August. You will receive a cancellation email of those meetings because we are those were scheduled outside of the clerk system as it stands today. So after June 10th, those pre-existing meeting invitations that you might have received will be canceled and you will be going to this website and joining this meeting that you see on the screen here. And I will take any questions if anyone has any at this time. I will also say that if you are familiar with our e-access, our CRIS platform, you can search for your case and there will also be a button here. If you're doing it on a case-by-case basis, there will be a button here to join the Zoom hearing from the e-access system, but this will be on a case-by-case basis. So if you need the full list of cases that are being heard in that session, on that court date, you'll have to go to the 18thjudicial.org website.
Lisa, a couple of questions have just popped in really quick. Can you restate, there's a little bit of confusion about prior video hearings being canceled. Can you restate what you said about that? And then can you confirm the date that this will be up and running? I think some people missed that.
Okay, the date is August 10th, Monday, August 10th. So if you have any Zoom meetings that have been scheduled via email and the meeting invite has been sent to you through someone in the domestic relations division, those meetings will be canceled and replaced with the meetings that you're seeing on my screen right here. So your date and your time will not change. It's just that the Zoom meeting ID and the passcode is going to be replaced with the one that is being generated automatically by our system as you see in front of you.
Can I jump in?
Sure.
Thanks, Lisa. So to all the judges that are on this call, we are now going to stop doing our invites for anything after August 10th. I should hear a noticeable roar, but I didn't. Two, remember, you still have to get your date from the domestic relations schedulers, not the clerk's office. That part is still in play. So don't forget that part. Thanks.
And then I would also like to say, because I know that many attorneys are practicing in multiple divisions, the law and chancery divisions are not using Zoom hearings once per case. So those will be more larger court calls where the judge will be hearing multiple cases for their Zoom meeting, but you will use this same interface to find your morning or afternoon sessions in the other civil divisions as well. But domestic relations is doing one Zoom hearing per case.
Okay.
Lisa,
I'm done if we don't have any further questions.
Lisa, would you be able to show, when you walked us into Chris, there was a thing on there for the court call. Would you be able to show everyone very quickly how we access the court call so you can see the judge's schedule?
Well, this is our Chris system, so
With the courtroom court call we now have available?
this attorney court call?
Yes, well, not attorney, but the courtroom.
Wendy, I was prepared to show that one.
Okay,
Okay.
Sean will show it. That's okay, thank you.
Thank you, Sean. It's right here.
Yep.
Okay.
Lisa, Judge Davenport's going to ask you a question really quick, so I'm going to let her unmute herself.
Question is, Lisa, how does the clerk's office populate the invitations? Do you take them from appearances? And how far back do you go with the appearances if it's someone is maybe has a different email?
That's a really good question. We are not generating emails. We are not sending email invitations to anyone, regardless of appearance or no appearance on the case. This Zoom meeting will be created if there is a date for that particular day that says for Zoom hearing on it. So we are not sending out email notifications to the parties or any attorneys of record on the case. So you still have to know what day and time your case is scheduled for, and then you use this interface to get the meeting information.
All right, thank you so much. Lisa, I'm sure we're going to get a lot more questions as this goes on. I'm going to let Sean do his presentation so that myself, Wendy, and Rebecca can sort through the questions. So if you can stay on, that would be super helpful. But Sean, you can take over.
Sure.
Okay. All right. So a couple of things that we wanted to go over with you first and foremost was to make sure the basic gist is e-orders are coming to the third floor. It's not a matter of maybe or halfway. They're coming. We're going to be moving to e-orders, which was something that was brought up years ago, and we kind of resisted because we weren't ready. The pandemic has made us ready. We're ready for e-orders. Judge Hayes had a few things she wanted me to make sure you all understood. First and foremost, the e-access, the e-order system is not the same as e-filing. Please do not prepare an order and file it with the e-filing system. Those are not orders. They will never be signed by the judge. And even if the clerk accidentally files them, they're not real orders. The CRIS system, the e-access system, is what we're going to use. So I'm going to switch over to share my screen with everyone for that. So here we have the screen that the attorneys will get. And the reason why I said I do it instead of Lisa is because I wanted them to see what we would see, not necessarily what the clerk's office sees, because you have a lot more fun stuff that we don't get. If you don't already have access, you would go here to request access, and then you will fill out all of that information. It's very simple. Luckily, I have an office manager who just did it for everybody in our firm, so I didn't have to think. But now I have a password, so I'm going to go right into login. And it should go quickly. Okay, so this is the screen that we see. As you can see, it's a little bit less than what Lisa had. One of the things that I wanted to show you first was the courtroom call that Wendy had brought up. So if I want to see the court call for the rest of this week in, I don't know, we'll say Judge McJoint, I'll pick 3009. And I can see his entire court call for today and tomorrow, and then I can go to the next screen to see other days. This is helpful for a lot of reasons. One, it'll tell you if your case is up. It's also to see if there are any slots available when you are doing the remote scheduling. That'll help assist with trying to plan if you can even get that date or time. So then once you've done that, now I'll show you the e-orders because that's probably the more exciting thing for everybody. When we go to our screen for e-orders, you're gonna see a list. And this will be a list of all the orders you've submitted throughout your case. I don't know if many of you will have a big screen. I have quite a bit, so it's gonna take a second. So this will show all the orders I've submitted. Some I've just submitted, some are complete, some are modified, returned. And then this will tell you whether or not you can download a copy. So I already downloaded. You get one free copy of your order in that regard. But if you want to do a new order in a new case, you click new order, type in your case number and the 5 initials of your case, last name of any party. Okay, we have several orders. Some of them we don't use. This name change order, don't use it. That's a name change order for chancery name changes. It's not a divorce court name change order. The open probate estate, obviously we won't. If you're doing a jail release order, you've got bigger issues in your case. So the orders that you'll most likely use are action order, blank order, rule to show cause, you may need an interpreter order, and the family center order. Now I know a lot of you are wondering, what about the GAL order? What about the mediation order? What about the trial order? So the tireless efforts of Jeff Davies and Lisa Goodwin at the clerk's office and everybody else who's been helping, the GAL order is in testing phase to test it to see if we will have access appropriately. That's what I got from Jeff yesterday. The mediation order and the trial order are in development. So that is still working. The family center order is the one where you can do supervised parenting time, parenting education, the mediation. So that is now available to us. If we wanted to do it, I would show you, but I'm going to show you more of a simple action order that's a little bit easier for everybody. Maybe. Okay, so I'm going to go to an action order in the case. My judge in this case is, I'm not going to talk about the case, but it is Judge Alvarado. I would fill in her name. If it's an agreed order, I'd mark it agreed. If it's not, I just mark continued to, and we would pick a future date. I'd say July 29th. I would pick one of her times that she normally has for these things. I would pick 9:15 would be my pick. That may not be an actual time. That may be a prove-up time, but you'll get the time from the judge. Status on GAL investigation. I'll learn how to spell later. And then if I want to, I can add additional things like parties to contact GAL within 7 days. What would happen then is if that was truly the order and it was clear, I would click send. I'm not going to click send right now because that would send an actual order to Judge Alvarado. She could reject it. We're not going to worry about that. I'm going to save it as incomplete. And I'll show you why that is useful. What is that? Prepared by. I forgot to tell who prepared it. Down here, it populates with your information. I'm going to put my name in. And I'm going to put attorney for Deborah Bell. And it's got your email, all the contact information. Now I will save it as incomplete. I know this is a little tedious, I apologize, but it is helpful to everybody to kind of see how this process works. And then it shows up here as an incomplete order. I can go back here to edit it. And I'll change it to 14 days. And then if I want to do a print preview, This will produce a PDF for me of what the order would look like. And I could send that PDF to my opposing counsel, get approval. My opposing counsel approves, I can click send it to the judge, and the judge is all set to go. That is, quite honestly, really the gist of it. I can tell you that I have sent judgments that I've cut and pasted into a blank order to Judge Gibson. I could do it here with any of the domestic judges. It's all easy to do.
John,
Yes.
it might be important to also note that if this were to be a Zoom conference, you would
yes.
need to check that box.
Yes, there is a box right here for video call. I apologize. You should pretty much presume that everything's going to be a Zoom call for right now and just click that box automatically.
And Sean, these are already live for domestic relations, correct?
The orders that are live for domestic right now are the action order, the blank order, the family center order, the rule to show cause order, and the interpreter order. You can use any one of those orders. They are live. You populate them yourself if you want to see a quick rule to show cause order, just because it might be good to see. It does give you options. Instead of having the 3 different orders that we had to dig through in the clerk's file box, it's all click an option. So this will make, I promise you, life a lot easier for all of you. The one other fun fact that some of you may not know, you can do this from your phone. There are people that do it in the courtroom from their phone, send it to the judge, it's off to go. So you have failure to obey, failure to appear, citation, failure to pay judgment, all of those. So you have all those options. You can click all of the information. Like I said, the clerk's office has made it absolutely easy to use. Anybody could do this. And Lisa, what do you have?
Oh, I'm sorry. We also have a guardianship order that's coming very shortly. And I also wanted to point out that if you have paralegals or if you have 2 attorneys within one DuPage County Attorney ID, which is a firm, then one attorney can prepare the order or a paralegal can prepare an order, and then the attorney can access it in court to amend it at the time, should there ever be in-person court again. But I just wanted to make sure that you knew that anybody within the same DuPage County firm ID can access the order on those cases. So it's not just limited to the attorney that originally created this electronic order. And then
John
we
and
did,
Lisa, really quick, a question that we're getting multiple times is how do we show these draft electronic orders to our opposing counsels or GALs before we submit them?
you can do the print preview and you can save it as an Adobe draft, and then you can share that via email.
Great, thank you.
The other thing is that after the order is signed, we now on our CRIS attorney portal, you can log in and obtain a copy of that signed order within 7 days of the file date. So you no longer have to come into the clerk's office if you're, opposing, or it doesn't have to be emailed to you. You can log in and download a signed copy from our CRIS attorney portal.
And Lisa, I can show them that on an order I did today. So
Perfect.
this is a case I had in front of Judge Cerny this morning. I submitted him the order. It says you are about to download the courtesy copy of this order. Once downloaded, you will no longer be able to you get 1 freebie from the clerk's office on orders. And I'm downloading it, and it's gonna come right there to my download, and there's my PDF. It shows that it was filed at this time by the clerk. It's got Judge Cerny's wonderful signature, and it's off to go. And now this is an official order that's in the system. So again, we have to stress, do not e-file your orders. E-filing your orders does not get them signed. This system is the system you want to use to get orders signed by judges. And then I can take that PDF from my downloads, which will be right here in my downloads, and I can then save it to my work file. I can email it to my opposing counsel. And somebody had asked, how do we send a draft? That order that I created as a draft right here is a PDF in my files. I could then email that to my opposing counsel, which this case would be Megan Giesler. I would send her the order, say, Megan, is this okay? And if she approves it, or if there's a GL that needs to approve it, I would then get the approval, and I would just click send, and the judge would have the order.
Great. Thanks, Sean. So we do have a lot of questions to get to. I think many of you have noticed that the Family Law Committee has started a weekly newsletter. We intend on taking any questions that we do not get to and answering as many as we can in the newsletter. So if we don't get to something, we will start getting to them in the newsletter. That's part of our goal. So feel free to put your questions out there. If we don't get to them, we will try to get to them at a later time. So we're going to start with the questions that were submitted to Rebecca and I. This question is for all of the judges. We'll start with Judge McJoint with his answer. Can each of you give us a description of how you are defining exigent circumstances in your courtroom for the purposes of in-person hearings? And Judge McJoint, we'll start with you because Judge Felice is also with you.
Sure is. It's defined in the administrative order. Is it a subjective definition? Yes, it is. My analysis is basically, I got to do something about this or something bad's going to happen. These people can't wait any longer. That's sort of my litmus test. Not very scientific, but that's my thoughts. But I'll let all the judges chime in.
Judge Felice.
I asked the people why they believe it's, or the lawyers why they believe it's exigent circumstances would apply. Give me some reasons so that I at least define this differently than something that's a non-emergency that might need some attention. And I would agree with Judge McJoint that some of these cases are starting to get to boil over, and you can tell that there's a great deal of pent-up demand that needs to be addressed. But I still want to have I want a record of some reasons rather than just find exigent circumstances before I hear a reason or reasons why. Usually there are some good reasons that are given, and then I'll make that determination, and then I'll allow it to be in person. And I've done that on several occasions, particularly if the type of hearing requires obviously evidence, testimony that's a given, but from parties in any type of detail. But there's got to be some impetus that tells us why it's more than just any other case that needs attention. But old cases, cases that have lingered, cases where there's serious issues of support, or issues related to children issues or child issues that need attention, all of those start rising to that level from my perspective.
Thank you. Judge Alvarado and Judge Sexton, you're in the same room, so can you answer? Oh.
Unmute.
My courtroom's open. Everything's exigent.
And in my courtroom, you know, I know that this is not a satisfying answer for a lot of you, but it, as Tim said, it really is kind of a case-by-case analysis. Most of us know our cases, so we know those cases that are playing games and those parties that aren't. And, you know, specifically, I think it goes to serious child-related issues and support issues. That's what I take a very close look at.
Great. Judge Davenport?
Anything with regard to a child, for sure. And right now, especially in the next couple of weeks, school registration is going to be an exigent circumstance for me. Finances, no, not so much. If I into the case a little bit, I'll look at the assets to figure out if there's a chance, if there is an adequate remedy. If there is, I'm not going to do anything. But basically, little children dying stuff is the issue that I got to address.
Thank you. Judge Douglas?
I go along, what Judge Felice said is kind of the way I'm going. And in particular, you know, those things that require testimony are going to be the ones that are going to be brought in. Everything else can be done by Zoom. There's really no problem with that. But if there's, you know, problems, and especially if things have been lingering for a long time and, you know, a lot of problems haven't been resolved, you know, if it's just financial, not a big deal. But, you know, things like relocations and child-related issues, I'm on the same boat. But as Judge Alvarado said, it is going to be on a case-by-case basis as well.
And Judge Reedy, you're last.
I'm always last. You know what, I kind of get the temperature of the litigants and the attorneys. Frankly, if they're willing to come in and we can fit you in, I'm ready to hear it. So if we can kind of fit you in and we can get you a trial and the litigants want to come to court, I say let's hear it. And you know, it's as I think to piggyback off of some of the things the other judges said. Obviously, it's going to be evidentiary matters are going to be heard in person because some of you know that have tried to do it evidentiary matters via Zoom. It can go off the rails pretty quick.
Thanks. Rebecca, go ahead.
Sure. This question is for Judge Alvarado. If both lawyers are signed into the Zoom meeting at their scheduled time and the Zoom says there is another section in progress, why would it be that the judge never initiates the meeting and then enters an order on his or her own? This is frustrating in that lawyers are waiting and oftentimes have other Zooms to get to and then find out they were waiting for nothing. Is there something the judges want us to do if we find ourselves just waiting in a Zoom?
Well, I read this question and, well, first of all, being that I'm always the host, I've never seen this error message of another session in progress, but I think the best way I could answer this question, assuming that this is going to continue to be an issue, even with the new process that we're going to have after August 10th, you know, I think what I would say to you is you have an appointment with a judge. Let's say your appointment on Zoom is at 9:30. You have from 9:30 to 9:40 set aside with this judge. I can't answer for you why a judge may not initiate that meeting. Maybe it's technical problems. Maybe the house is on fire. I don't know. So I don't know the answer. Okay, well, hang on one sec.
Okay.
Let me say this. Judge Sexton thinks she has a better answer, and I'm
Not
sure
a
she
better
will.
answer. It happens to me all the time.
Okay, but what I will say to you is if your appointment is at 9:30, you have an appointment with me from 9:30 to 9:40. If I don't let you into that meeting or initiate that meeting by 9:40, it's over because I have another meeting at 9:40 from 9:40 to 9:50. So I would say to you, don't sit online waiting forever for hours. Just don't do that. And if the court enters an order just arbitrarily, let's say setting another date, and that doesn't work for you, just call the receptionists and tell them that you need another Zoom ASAP. And that's the best way I can answer that. But Judge Sexton has an answer.
I'm a terrible inviter, and usually it takes me 3 stabs at an invitation before it's right. So sometimes I forget to delete the first batch, and you're responding to those, and I'm on the 3rd one. So I'm trying to learn to delete as I go, but that's really how that happens a lot. The other thing, people call my secretary Deb. She comes down and says they're waiting for you. Then I usually find another link and I get on. Or you're not supposed to, email me at the address and it pops up and I can invite you in. But it's my error, it's not anybody else's.
So there we go.
Thank you.
Judge Davenport, I'm going to have you jump in here too, because your question is pretty similar. If we have a case set for 10:15 and it's now 10:20 and the Zoom hasn't started, how long do you think we should wait for you or any of the judges?
I'm going to apply the TA rule from college. So I'm going to say 10 minutes because you know that my next Zoom starts at 10:25. So it's not fair to you to make you sit. So I would say wait until the next scheduled time would happen, but 10 minutes is fair. That's what I'm doing for the lawyers. If it's on at 10:10 and no one's there, I'm going to wait, and at 10:20, I'm going to end it.
And Rebecca, before you ask your question, Judge McJoint, we've been getting a lot of comments from people that when the new system starts up and we log into the page and hit the links, if their Zoom hasn't started, is it appropriate to jump onto somebody else's link to see if their case is still going? Can you comment on that?
Well, I've done it under the old system where I'm falling behind. I'll close the meeting, go to the next meeting, and say I'm coming back. I'll reopen the meeting, then I'll go to the first meeting and reopen that one. You can do all that. I think most of us are staying on time, because I haven't heard many complaints about it. And somebody said, why are we doing these separate times? To stop everybody being there at the same time. Our volume is too large for us to have just open meetings. And when we reopen, now we're not going to have a gaggle of people in the room at the same time. So that's the purpose of that. So I think what we're trying to do is stay on time like a good train, a good on time train. And sometimes we do get a little behind, but that's what I've done in the past. I've jumped to a meeting, next meeting, and come back to the other meeting, just to make sure everybody gets their chance.
Thank you, Judge McJoint. This next question is directed to Judge Felice. Should we get on early for our Zoom calls? If so, how early? If you are running ahead of schedule, will you log on early?
I will. Actually, that's a really good question. You can actually log on Zoom at any time. It's not at the time that the meeting is set for, although we try to keep track of the times that are set. But if I'm done with a Zoom ahead of you earlier, I will look to see if you are there early. I've done that today several times because I had a real tight schedule. So I got on 5 minutes early, maybe 10 minutes at the most. I don't try to get on much earlier than that because I don't find anybody tries to get on any earlier than usually 5 minutes at a time. But if so, and if everybody's there, I'll start it right away. There's no reason not to, and I think it helps. And it gets things moving along as quickly as I can. So the one thing that I think as a takeaway is just remember that Zoom can be started early. It can, in some Zooms, by the way, people have sometimes got an AM instead of a PM or a PM instead of an AM. Doesn't matter. You can still log on. And I think we all know if there's something set at 10 PM, that's not going to happen at 10 PM. It must be AM. You can always check, and that's what you'll be told from the schedulers as well. That would be my suggestion. So yes, if people are ready early and you have the time, get on there in the waiting room a little bit earlier and maybe you'll get done quicker.
Great, thank you. Judge Reedy, some judges have said that they are waiting for both attorneys or attorney and a pro se to log into the Zoom before they will start the session. However, just as with in-person statuses, sometimes one attorney covers the matter, so both attorneys don't need to attend. Is there something the judges want us to do to let them know that this is the case so that they can start the Zoom when one attorney is there?
Yeah, I guess to, again, piggyback off of what Judge Felice said is if you're on early and if I'm ahead, I'm going to try to go on, and I'll just talk to you and let you know if you're on, I'm going to see that and try to address your case early. I kind of use this analogy. We're basically airline traffic controllers. We're landing planes and having them take off in 10-minute slots. And that's really all the time we have for you. And I'm not sure if I'm completely answering your question. So a minute or two into it, if I just have one attorney, I'm gonna call the case, put it on the record, say, hey, look, the other attorney hasn't gotten in here. I got to use the time valuably and get the case called, have them give the notice and the order to the other attorney. And I'll usually probably do a clerk to notify. And I know sometimes, I've heard back, well, the other attorney, got in a couple minutes late. I'll apologize to them at a later time. And if they need to get the case up to be reheard, we'll try to do that as early as we can.
And does anyone, maybe this is where Lisa can jump in. There's a lot of concern from attorneys that the pro se litigants will not be getting this information. What does everyone recommend that we make sure pro se litigants get this information with regards to the new scheduling?
Well, you still need to schedule your date and your time slot with the domestic relations scheduler. So you will know what day and time your next court date is. So if you use the www.18thjudicial.org website, there is no login for that. That is different from our CRIS attorney portal. So that the website is available to pro se litigants. So you should direct them to go use that website. And they will be able to either click on that Zoom link themselves, or they will be able to use the meeting details to log in manually. But you do not need to email them the meeting ID and the password to their meetings if they have access to the www.18th Judicial website.
Great, thank you. Lisa, since you're unmuted, here's the question. Can we start doing the e-orders now, or are we holding off on doing those?
Yes, you can start using the e-orders now.
Okay, great. Rebecca, go ahead.
Sure, this question is directed to Judge Douglas, but Judge McJoint was weighing in a little bit, so if you have anything to add, please do. Is there a discussion of doing morning Zoom sessions with one time slot for multiple cases like in other counties? For example, 9 a.m. all cases scheduled for that time log in, 9:30 a.m. all cases scheduled for that time log in. It may be more efficient than having a specific time and waiting for that one case to show up, be on time, log in successfully, etc. The judge could address cases which are ready if everybody logged in at the same time, and it would be more like it used to be in in-person court.
Okay, well, we're all like Michael Douglas in Falling Down. We'd like things to be the way they used to be. They're not gonna be. We've had discussions on this, and we felt that we're doing the attorneys a favor by having individual times. You got a 10-minute slot when you got to be there. That's all you have to wait for us, give or take a minute or two on either side. I've heard horror stories from the attorneys where they're waiting an hour and a half in Cook County in a cattle call room for their case to be called, and they look away a minute and all of a sudden their case was called and now they're back in the queue. So we've had discussions. We've set this up. It's in place now. It's not going to be changed. Judge McJoint, if you disagree with me that there's a possibility of changing this, let me know. But I mean, I think in our meetings and our discussions, it's always been it'd be too hard to change this ship mid-course.
Yeah, I agree with everything Judge Douglas said, and we've had this debate repeatedly, and you have to remember someday is going to come when we're going to be open, and a lot of people are going to come back to the building, and our cases are spread out, so we won't have 15 lawyers in a line out the door waiting to be called. So because people will feel unsafe even 6 months from now in that situation, I predict. So no, we ain't changing.
Thank you. Judge Felice, this one's for you. Are there suggestions that the judges can make for having more productive statuses in pretrial conferences? 5 minutes for statuses and 15 minutes for a pretrial conference is pretty tight. What can we do to make sure that the judge has all the information they need?
Well, first of all, I will tell you that if I can give you more time, I will. And with regard even to statuses, I'm using presentation times. I'm using earlier times during the day, fill those slots, as well as Thursdays and Fridays if there's availability, Wednesdays, Thursdays, Fridays. So this way, if we have more time available, I'll give it to you. Oftentimes, however, the slots are pretty close together and I don't have that luxury. With regard to pretrials, a little bit different, because when I said pretrials, I typically are doing them at 8:30. And if somebody says, look, it's a more complicated pretrial, I'll even try to block out as much as an hour. I've given several people hour pretrials, pretty routinely half-hour pretrials, and I will give them a second and even a third pretrial if they need it so they can get their case completed. So the time frames on the pretrials, I think, are more likely to be expanded as needed. And if you have a status that you think is more involved, so you can let the court know when we're setting it ourselves. We'll try to give you maybe a different time frame that's earlier than the 10:30 for statuses, using some other time slots that might be available.
Following up on that, Judge Davenport, has there been discussion to increase the time slots for pretrials? Since it's hard to get into court for a hearing, could it be beneficial to give more pretrials in an attempt to resolve more cases?
I think it is up to every judge how they want to do it. Normally when I do a pretrial at 8:30 in the action order, I block out the 8:30 and the 8:45 slot. So you'll always have a half an hour no matter what. I also do pretrials at noon for an hour every day in July, every day in August is booked. So if you want a pretrial, figure it out. If the judge doesn't have an afternoon at 1:30 or 2:30 or 3:30, ask for a pretrial. They don't always have to be at 8:30 in the morning. So try to be creative. I've got one this afternoon at 3:30, so ask. And you know, if the time isn't taken, we'll do it. Don't be locked into 8:30 in the morning.
Thank you. Judge McJoint, can you please describe the preferred procedure for an emergency matter? Will the emergency be heard in person? What time should be inserted on the notice of motion? What should we do if we want an emergency to be heard by Zoom?
Well, as you all know, we're not open except for emergencies, orders of protection, and now exigent cases specially set. As to emergencies, you can come in person. Obviously, it's a presentment, so it would be in the morning. And it has to be an emergency. And we all know that's the first test. And I think the procedure hasn't changed, pre-COVID or pre-Zoom. So the issue is whether or not somebody's hair is on fire. That's really the point. And if they are, we're going to have a hearing right on the spot, in person.
Great, thank you.
Judge Sexton, if we have a case in your courtroom, should we always plan on being in person, or would you prefer that we attend via Zoom?
I prefer in person, and that's why we opened up. If there's a lawyer on the other side, and I do have those cases, Zoom is fine. But if you've got a pro se on the other side, they come in, they don't Zoom very well. And if they do, they're late in their car and they're calling on the phone and they're calling my secretary. It's very inefficient. So I'm open. Anybody who's been in the courtroom knows how far away you are from anybody else. It's really safe distancing, and if you don't have your mask on, you're not coming in the courtroom, that sort of thing. I am taking precautions. We clean up things. I find that we're just getting more done in person, probably because we're used to it, but Zooms aren't real good with pro se. So I would say plan on in person.
And then can somebody just answer, we're getting a lot of questions for Judge Cerny. He has a lot of pro se litigants as well. Should his court cases be in person, or if there's attorneys, should they count on Zooming in? Should they flip those to Zoom? Does anyone know? Judge McJoint, I see you.
I missed it because I was talking to somebody else. Can you repeat? I apologize.
No, it's fine. There's a lot of questions for Judge Cerny because he has a lot of pro se litigants in his courtroom.
Yes.
If there's attorneys, should they flip those to Zooms or should they come in person?
Well, I think the preference is Zoom because there's a virus. And so if you have a choice, to me, the choice is pretty simple. We want less people in the room near each other. So Zoom is preferred. I think, though, his challenges are similar to Judge Sexton's because the pro se litigants don't do Zoom well. So he might have more hybrids. Somebody there in person, somebody on the Zoom call. And that's another thing that's obviously going to start happening more and more, I think. So I guess that's my answer there.
Okay, thank you. Judge Davenport, if we have a trial date that was set before the latest administrative order and we have not received contact from the judge and we cannot get a status date before the trial to check on the status of that trial, what's your recommendation for us to find out if that trial is going?
I would suggest get both attorneys on the phone, contact our scheduler, and ask if you can set up even a phone call conference with the court, okay? Just to find out what's going on. Most cases that are set for trial, it's because there's been other activity going on. So it would be rare to me to think that someone had no idea what was happening on a trial date. But I would say if you can get both attorneys and you both want to come into the courtroom at 9:15 in the morning and find out, you don't have to file a pleading, just walk in if the two of you can do it. It's exigent in that you have a right to know is the trial going or not. But that's kind of my suggestion. Not great, but that's the best answer I've got. Walk in or call in.
Great, thank you. Hey, Wendy, do you have any questions? We have a couple of minutes that you want to throw out there.
One of the questions that popped up is there a deadline or time that they want orders submitted via the electronic orders or via email? Because some counties have had a deadline of 2 or 3 p.m.
That would be great. That would be absolutely great if we could do that. Yeah. It helps us. Our sheets for the next day are printed at around 11:30 in the morning. So it's not as critical that we get them, but clearly it is important that we get them by 2 or 3, especially if you're doing issues of injunctive relief or something. You want to get that order in sooner than later.
And you're currently still accepting agreed orders submitted via email, correct?
Yes.
Yeah, everybody was nodding their head. So
Yes.
in case you're not looking at your screen, the answer is yes.
And that won't stop after we open. It will not stop. Okay?
One question that we've received is, even when the electronic orders go in place, can we draft our own orders? Is there a way to update those, put those into the system? Sean's answer is yes.
Yes, I don't want to speak for the judges because they're judges, I'll let them. But if you have an agreed order, the only problem is if it requires signatures or you want signatures, we haven't mastered that issue yet. And I don't want to scare Jeff Davies because that's something that I just asked him about yesterday. But if it's just a body of an agreed order that the attorneys all approve and you can just cut and paste it into a blank order and submit it, but signatures can't attach those yet.
And I should also chime in and say that if you do submit an electronic order late in the day, that if you would give a phone call the judge or the secretary and let them know that one is there, because if you do submit it late, it may not automatically pop up on the judge's list of orders if you happen to miss that window.
Lisa, may I ask you a question about that?
Sure.
Okay, so as an example, someone submits an order to me late yesterday that was incomplete in terms of they were waiting for their co-counsel's approval for that order, okay? It didn't come in and it has since disappeared today. So is there like a 24-hour rule or anything where if the incomplete order is not approved or submitted that it disappears, or what happens to it?
It definitely doesn't disappear, but if you are looking in your orders to sign screen, there's an option there to view all the orders, and we can cover this on some judges training in the future, but there's a way to find that order if it didn't make it in time for the call when the call got generated the day before.
Even if it's incomplete?
Oh, if it's incomplete, no, you cannot see it until they send it to the judge. But if they sent it late, then there's a way to find it. But if it's incomplete, you cannot see it.
So my question is, do the incompletes disappear? So in other words, the attorney sends it out, opposing counsel doesn't approve it. It's saved as incomplete. Does it disappear after a period of time?
That period of time is around 1 year.
Okay,
so,
good.
Yeah.
Okay, great.
Lisa, one more question for you. Do you know approximately what time the links will be generated the day before a court procedure?
I can try to find that out for you. Usually we start running all the overnight processes in ducks. I want to say around 10 p.m., but I can try to find that out and I will let you know shortly.
Great, thank you.
I can answer that. Yeah, it'll be generated in the morning.
11:30.
Yeah, 11:30 a.m. for the
next. For the next day.
Yeah.
Perfect. Thank you. So it is almost 1 o'clock. I think that we're going to end for today because I know the judges have their court calls to do. We have various court calls to do. That being said, we do have a list of all of the unanswered questions. We will start going through them. We'll try and get you guys answers. That's why we're here. Judge McJoyne, I see you've unmuted yourself, so feel free to jump in.
Yeah, I just don't want to miss the one thing Judge Alvarado brought up at the beginning of the meeting. The email that has your Zoom invite, at least the old ones, not the new system. You can't use that email for anything. You have to use our public emails to communicate with us. I want to make sure all the lawyers understand that.
Yes, so don't respond to the Evite. Don't send the judges emails to that Evite. Most of them are getting deleted, just so that you guys are all aware. So again, I want to thank all of the judges. I want to thank everyone from the clerk's office. Lisa, thank you so much for that information. Sean, thank you for screen sharing and showing us the new future for all of us. Barb, thanks for setting this up, and everybody have a great afternoon and great rest of the week.